ownership of the bundle of rights to real estate. Letter B, the right of a buyer or lender to obtain ownership under certain circumstances. Letter C, possession of a deed. Letter D, absolute proof of ownership of real estate. Unit number 6, question number 1. Which of the following best describes the concept of legal title to real estate? And the answer is letter A, ownership of the bundle of rights to real estate. Okay, so here we just want to be able to know and research what is legal title and what is equitable title. Okay, and legal title is an actual document. The document that we're dealing with is the deed. But ownership of the bundle of rights to real estate really signifies the fact that you have legal title. The right of a buyer or lender to obtain ownership under certain circumstances is not the case. Absolute proof of ownership of real estate is not the case. And possession of a deed merely by itself does not indicate full legal title. So the most complete answer here would have been A. Legal title is ownership of the bundle of rights. Unit number 6, question number 2. Constructive notice of ownership of a parcel of real estate is primarily demonstrated through letter A, direct inspection to see who is in possession. Letter B, title insurance. Letter C, title records. Letter D, a construction permit. Question number 2, constructive notice of ownership of a parcel of real estate is primarily demonstrated through and the answer is letter C, title records. Okay, so constructive notice is a vocab phrase that you definitely want to know versus actual notice. And you'll find these inside of unit number 6 here. So constructive notice is an important one. And it's primarily demonstrated through researching title records. Actual notice will be found inside of title records. So that's basically the direct way to do it, through title records. So constructive notice. A direct inspection to see who's in possession is not evidence of constructive notice. And title insurance is not. Title insurance is insurance that we get to verify and solidify our claims. And a construction permit has nothing to do with this. So that one's a complete outlier. So letter C would have been the correct answer for this question. Unit number 6, question number 3. If a person dies with no legal heirs or relations and has left no valid will, what happens to real property owned by that person? Letter A, it's taken by the state according to the process known as Escheat. Letter B, it is reconveyed to the previous owner in the chain of title. Letter C, it is taken by the title insurance company according to the process called involuntary alienation. Letter D, it is conveyed to the highest bidder at public auction. Question number 3, if a person dies with no legal heirs or relations and has left no valid will, what happens to real property owned by that person? And the answer, letter A, it is taken by the state according to the process known as Escheat. Okay, so Escheat is definitely a vocab phrase that y'all definitely want to know for your exam. So Escheat, when somebody dies without a will, they die intestate. We want to know that phrase. So intestate, Escheat, and this exact process. Obviously, it's not reconveyed, letter B, to the previous owner. That's crazy. It is taken by a title insurance company according to the process known as involuntary alienation. No, but Escheat is a type of involuntary alienation. Alienation is a really important vocab phrase as well, so you can look that up. But alienation means to transfer, and it is conveyed to the highest bidder at a public auction. That's not the case. If the state does take it over, the county takes it over, they can auction it if they want to, but it's not this automatic process. A, all day, is the answer to number 3. Unit number 6, question number 4. With the exception of a Torrens certificate, The best evidence of marketable title is letter A, a signed deed. Letter B, a title certificate. Letter C, title insurance. Letter D, an attorney's opinion. Question number 4, with the exception of a Torrens certificate, the best evidence of marketable title is and the answer is letter C, title insurance. Okay, so if we have land court and then we have a Torrens certificate, then that land court Torrens certificate is the best evidence of ownership. But many jurisdictions have recording and registered land, and when we're recording, we get a deed. And to back up that deed, we get title insurance. So you definitely want to know what is title insurance. You want to know, and you'll learn in this particular unit what is a title certificate and what is an attorney's opinion. But the attorney's opinion is not the best evidence of marketable title. That's just their opinion. So we kick that out. A signed deed would be a good selection for a lot of students, which proves the best, but a deed could be signed or forged or anything else. We really want title insurance to have a big title insurance carrier back up the play. So this title insurance is really the short answer here for something barring a Torrens certificate. Okay, unit number 19, question number 1. Which of the following is true with respect to real estate or real property taxation by the federal government? Letter A, it may impose ad valorem property taxes and capital gains tax. Letter B, it may not impose property taxes nor tax liens. Letter C, there are no federal ad valorem taxes on real estate. Letter D, it may impose ad valorem tax but not capital gains tax. Question number 1, which of the following is true with respect to real property taxation by the federal government? And the answer is letter C, there are no federal ad valorem taxes on real estate. Okay, so bottom line here, the federal government doesn't impose real estate tax. The federal government imposes capital gains tax. So if we go down to D, right, it may impose ad valorem tax. That's not true, but not capital gains tax. As a matter of fact, D is entirely untrue, and it's looking for what is true with respect to real property taxation by the federal government. The only thing true here is that there are no federal ad valorem taxes. It's states that tax real estate in the states that the property is located in. It may not impose property taxes nor tax liens. Oh, the government can impose tax liens, so this isn't correct. And then A, it may impose ad valorem property taxes. Not correct. It cannot. And capital gains tax. Yes, that's true, but it's only partially true. Okay, so C is the complete correct answer. Unit number 19, question number 2. Ad valorem taxes are based on letter A, the replacement value of property. Letter B, the assessed value of property. Letter C, the millage value of property. Letter D, the broker's estimate of value. Question number 2, ad valorem taxes are based on, and the answer is letter B, the assessed value of property. This is straight, right to the punch. Ad valorem taxes mean according to value. Ad valorem taxes are based on the assessed value of the property. All right, not the broker's estimate of value, we kick that out. Not the replacement value of the property, we kick that out. This isn't insurance. And the millage value of the property, if there's any mills that are calculated, then we determine those in the calculations. Not the millaged value, it is the assessed value. Unit number 19, question number 3. A millage rate is derived by, letter A, dividing the tax requirements by the tax base. Letter B, multiplying the tax base times the tax requirement. Letter C, adding an inflation factor to the prior year's tax rate. Letter D, dividing the tax base by the tax requirements. Question number 3, a millage rate is derived by. And the answer is letter A, dividing the tax requirements by the tax base. Okay. How do we calculate millage? You want to know the definition of millage. You'll find that in this unit, unit number 19. Dividing the tax requirement by the tax base will determine our millage rate. And then when we apply the millage rate, then we can determine what the taxation is. Okay, and that's the way to do it. That's pretty much straight out of the book, and you'll be able to find that in any of your real estate books that you're looking at in the taxation units. What is millage? Unit number 19, question number 4. An equitable right of redemption, letter A, allows a holder of a tax certificate to redeem it for a tax deed. Letter B, gives a delinquent taxpayer a grace period prior to the tax sale to pay the property taxes. Letter C, gives a holder of a tax deed the right to acquire the property named in the tax certificate. Letter D, gives a delinquent taxpayer a grace period after the tax sale to pay property taxes. Unit number 19, question number 4, an equitable right of redemption. And the answer is letter B, gives a delinquent taxpayer a grace period prior to the tax sale to pay the property taxes. So equitable right of redemption is a vocab phrase, and the counterbalance to that is something called statutory right of redemption. So you want to look those two up. What is the statutory right of redemption and what is the equitable right of redemption? Now the statutory is after the sale. So it gives the delinquent taxpayer a grace period after the tax sale to pay the property taxes. That would be the statutory right of redemption. Here in Massachusetts, it's 6 months. But all of us have the equitable right of redemption, which means that if we can get current on the delinquent taxes, there's a grace period prior to the tax sale to pay the property taxes. That is the equitable right of redemption. Answer is B. All right, what I want to do here is I want to introduce y'all to some national exam practice questions. So what we're going to do is I'm going to give you about 5 just so you can check them out. Now, don't freak if you don't know the answers to these. You're going to learn about these during the time that we spend together. Enjoy them, and I'll see you soon. Question number 6. A contract in which both parties have fulfilled their obligation is considered to be letter A, pending. Letter B, executory. Letter C, fully executed. Letter D, voidable. Question number 6. A contract in which both parties have fulfilled their obligation is considered to be, and the answer is letter C, fully executed. These are simple. These are basic contract questions, basic fundamental contract questions. You want to know, what is executed? What is executory? Those are actual phrases. Voidable, void, valid. You want to know all of those basic definitions. They will serve you well, trust me. And these are easy questions. So again, a contract in which both parties have fulfilled their obligations, this is textbook fully executed, which means all the parties have fully performed on all of their obligations in the transaction. And a fully executed contract, sometimes they'll say fully executed, or they can just say executed contract, which means fully completed. All right, so executory versus executed is really the what was that matter here, and that's a good simple one for contracts and fundamentals. Question number 7. The Sherman Antitrust laws, which are designed to protect buyers and sellers from unfair competition and predatory business practices, prohibit competing brokers from letter A, group boycotting of other competing brokers. Letter B, price fixing of commission rates. Letter C, geographically dividing the market to decrease competition. Letter D, all of the above. Question number 7, the Sherman Antitrust laws, which are designed to protect buyers and sellers from unfair competition and predatory business practices, prohibit competing brokers from, and the answer is letter D, all of the above. All right, so this question is actually really cool, and I want to sort of illuminate a couple things. Number one, sometimes you'll see this on exams, where they'll give you something, like they gave you the Sherman Antitrust Act, and then they explained what it was, which was sort of a give me. Now, you might see Sherman later, so this could be exceptionally helpful. This would make a great use case of clicking the mark function on an exam. Mark this one, and then you can come back to it. And it doesn't mean that you don't answer it, but you want to mark it as if you want to go, hey, that's the definition of Sherman Antitrust. I should keep that handy in case I need to re-reference that. And that's what I would do. I would just mark and go, okay, that's something that I want to know. Now knowing that Sherman Antitrust, all of these A, B, and C are all situations that would be applicable to violating the antitrust laws. And all of these are good examples of how the brokerage industry could be found in violation of Sherman Antitrust Act or local state antitrust laws. All right, so this is an excellent question. This is a basic what is antitrust question and how does it function, and a good useful one to keep handy as you're studying for your exams. Question number 8. Which of the following is not part of the bundle of rights of real estate ownership? Letter A, the right of exclusion. Letter B, the right of enjoyment. Letter C, the right of execution. Letter D, the right of disposition. Question number 8, which of the following is not part of the bundle of rights of real estate ownership? And the answer is letter C, the right of execution. All right, so these are straight. What are the bundle of rights? And there's many authors, depending on the book, there are going to be usually 5 or so of the bundle of rights. And with the bundle, the right of exclusion, the right of enjoyment, the right of disposition were all textbook rights or the bundle of rights, also known as equitable title, by the way. If you take my class, you'll learn it in a couple of different ways. I would just memorize these. Now, something to just take note of, the first 3 all are with E, right? So exclusion, enjoyment, execution. Sometimes students are going to go, okay, these are all kind of similar. I bet you these are all the ones. And the right of disposition, which is the outlier, is probably the answer if they just didn't study this. So I would memorize what the bundle of legal rights are, the bundle of rights. You'll see them in your textbooks. You'll look them up, and then you'll just memorize them. There's usually 5, and execution is not. One of them, exclusion, enjoyment, and disposition, are. Question number 9. The act of a broker using the funds from a trust account for the purposes other than what they were originally intended for is called letter A, commingling. Letter B, domingling. Letter C, installment. Letter D, conversion. Question number 9. The act of a broker using the funds from a trust account for the purposes other than what they were originally intended for is called. And the answer is letter D, conversion. All right, look, I laughed because domingling is a very funny word to me, and I was like thinking about it as I was saying this, and I was like cracking up inside. I was laughing actually way more than I showed. All right, so domingling clearly is just some nonsensical BS answer. Commingling is a definite thing. Commingling is mixing our funds with client funds. That's a big no-no, right? And installment, really incorrect. So B and C are absolutely throwouts. And then the question is, well, what was commingling and what was conversion? I learned about those in my real estate class, you're thinking, and you're just looking to place a definition. So the act of a broker using the funds, using is the operative phrase here, using the funds versus mixing the funds from a trust account for the purposes other of what they were originally intended for is called conversion. So conversion is the use of funds. Question number 10. Which of the following involves offering an asset of value in exchange for a loan? Letter A, hypothecation. Letter B, due diligence. Letter C, proof of funds. Letter D, concession. Question number 10, which of the following involves offering an asset of value in exchange for a loan? And the answer is letter A, hypothecation. This is standard vocab phrase territory for us to want to memorize. What is hypothecation? You will find this in your finance section, your basic finance section inside of any of your books or materials that you guys are using. That's where you're going to find this, hypothecation. And this is a fairly decent definition of it. Which of the following involves? It's offering an asset of value in exchange for a loan. And that's what hypothecation is. Hypothecar means sort of what a mortgage is here, in the U.S. We call it a mortgage loan, and in other parts of the world they call it hypothecar, which basically means to hypothecate, which means to pledge a piece of property in exchange for a loan. This is classic textbook. The other items here, due diligence, proof of funds, concession, all phrases, all vocab phrases, but they are not the definition of what number 10 is asking for. This is a pretty straight to the point type of question. Question number 11, which of the following are addressed under the TRID, the TILA-RESPA Integrated Disclosure Rule? Letter A, written estimates of terms and costs of a mortgage loan must be provided to a consumer. Letter B, lenders are required to provide the consumer with the good faith estimate of credited closing costs within 3 business days of receiving a completed loan application. Closing disclosure replaces a previously used document known as a HUD-1 form. Letter D, all of the above. Question number 11, which of the following are addressed under the TRID rule, which is known as the TILA-RESPA Integrated Disclosure Rule? And the answer is letter D, all of the above. Okay, so TRID, the TILA-RESPA Integrated Disclosure Rule, is definitely something that you will see on examinations. Luckily for the brokerage community, it isn't as comprehensive as you might need to know it for other examinations. For example, let's say the mortgage loan originator's exam. You need to know a lot about this TRID rule. But for us in brokerage, TRID is just some of the basics. So when you're studying for this, anywhere you are, I would focus on the basics, like these in multiple choice format. This is a great explanation of understanding what TRID is. If you can kind of boil it down to this and just kind of know a little bit of the timing for the disclosures, you're probably sitting reasonably pretty when you're going to take this examination. Many authors overwrite this section, as a matter of fact. They go into a lot of detail, of which I don't really think you need to know, or at least limit your exposure to it. Get good at other things when you're playing the test-taking game, right? We're just trying to get through this examination to get you all licensed is my sort of goal here. So, but this one was a good question of understanding what TILA-RESPA is. A, B, and C are all true, and therefore D is the correct answer. All right, that wraps this session. Thank you all very much for attending. Now, before you leave, give me a quick response in the chat so I know you're good to go. And as soon as you do that, then we can log off and we'll see you in the next session. Thank you very much. Good luck with your studies. We're looking forward to having you back in the next session. See you then.